July brought significant immigration developments, and if you are not following closely, it is important to understand what changed and what remains in effect as we move into August. Before reviewing July, it helps to briefly revisit late June, when several Supreme Court decisions shaped what followed. On June 25, 2026, the Supreme Court issued multiple immigration-related rulings. First, the court held that certain temporary protected status (TPS) terminations are largely shielded from broad judicial review, meaning courts may have limited ability to block TPS designations from ending. Second, the court ruled that asylum seekers stopped at the border before physically entering U.S. territory may not be considered to have arrived for purposes of certain asylum protections. Third, the court allowed immigration officers broader discretion in reviewing green card holders returning from extended travel abroad. 5 days later, the court rejected an executive attempt to restrict birthright citizenship through presidential action, holding that such a limitation cannot be imposed by executive order. However, the court's reasoning suggested that if Congress were to pass legislation addressing birthright citizenship, that issue could return to the courts under a different legal framework. A bill has since been introduced, but as of now, birthright citizenship remains unchanged under existing constitutional interpretation. Now let's turn to July developments. Public charge rule change. On July 16, 2026, the Department of Homeland Security formally rescinded the 2022 Public Charge Regulation. Under the 2022 rule, only certain cash welfare programs and long-term institutional care were considered in public charge determinations. Benefits such as Medicaid, SNAP, and housing assistance were not counted under that narrower framework. With the rescission, immigration officers will again apply a broader totality of the circumstances test beginning September 18, 2026. This means officers may consider a wider range of means-tested public benefits as part of evaluating whether a green card applicant is likely to become a public charge. The new approach does not create automatic denials. Officers must weigh both positive and negative factors, including age, health, education, employment history, assets, and sponsor support. However, applicants who have relied on certain public benefits may face increased scrutiny after September 18th. For applicants preparing to file for adjustment of status, timing may matter. Applications properly filed before September 18th are expected to be adjudicated under the current framework. After that date, the broader standard applies. F1 and J1. Duration of status changes. On July 17th, DHS finalized a rule ending automatic duration of status, D/S admission for F1 and J1 visa holders. Previously, students admitted under D/S could remain in the United States as long as they maintained valid student status. Under the new rule, beginning September 15, 2026, certain F and J entrants will receive a fixed period of authorized stay, typically up to 4 years, rather than indefinite D/S. Students must monitor their I-94 records carefully and file for extensions if needed before expiration. The grace period following program completion is also being shortened. H-1B fee litigation. The H-1B program continues to face litigation over a newly imposed $100,000 fee per petition announced in late 2025. In June 2026, a federal judge in Massachusetts ruled the fee unconstitutional, holding that it constituted an unauthorized tax. The administration appealed and requested a stay, but the appellate court declined to pause the lower court's ruling. Meanwhile, a separate district court in Washington, D.C. reached a different conclusion. Because the First Circuit declined to stay the Massachusetts ruling, the fee is not currently being enforced. The issue may ultimately reach the Supreme Court. Additionally, the fiscal year 2027 H-1B cap has already been reached for both the regular and advanced degree categories. Denaturalization efforts. On July 20th, 2026, the Department of Justice and DHS announced expanded denaturalization enforcement. According to agency statements, the current administration is pursuing a significantly higher volume of denaturalization referrals compared to prior years. Denaturalization requires a formal federal court proceeding. Citizenship cannot be revoked administratively. The government must prove fraud or other statutory grounds before a judge. While enforcement volume has increased, the legal standard remains unchanged. TPS developments. TPS protections remain in flux. Haiti and Syria. TPS protections were allowed to lapse following Supreme Court developments. Work authorization for affected individuals has expired. Honduras and Nicaragua. Litigation remains ongoing and final outcomes are still pending. Venezuela, TPS has ended for most beneficiaries, though a limited group retains work authorization through October 2, 2026. Ukraine. A federal judge ruled that work permit extensions remain valid for now, though long-term clarity is still pending. Lebanon. TPS was extended for 6 months through late November 2026. Overall, approximately 1 million TPS beneficiaries have faced termination or uncertainty since 2025. Enforcement activity. ICE reported record enforcement activity in July 2026, averaging approximately 1,600 arrests per day. As of July 20th, 2026, more than 356,000 removals had occurred in fiscal year 2026, which began October 1st, 2025. DHS reports that a majority of recent arrests involve individuals with criminal charges or convictions, though advocacy groups have disputed aspects of those figures. African consular consolidation. The State Department has consolidated certain visa operations across Africa into regional hubs. Several U.S. consulates that previously processed immigrant and non-immigrant visas will now refer applicants to designated regional processing centers. Applicants should verify their assigned interview location carefully and plan travel accordingly. Visa Bulletin and Expedited Appointment Pilot. The August 2026 Visa Bulletin included significant forward movement in several family-based categories. Applicants should review the final action dates and filing dates carefully to determine eligibility. The State Department has also launched a pilot program allowing certain non-immigrant visa applicants to pay a $750 fee for expedited interview scheduling. This does not guarantee approval or bypass administrative processing. Looking ahead, September 2026 will be a critical month. The new public charge framework takes effect September 18th, and student visa duration changes begin September 15th. Many of these developments remain subject to ongoing litigation. It is essential to monitor not only policy announcements, but also court decisions that may alter implementation. This summary is provided for general informational purposes only and does not constitute legal advice. Immigration law is highly fact-specific. Individuals with pending or future cases should consult qualified immigration counsel to evaluate how these developments may affect them.